5 seconds to go. Start. The relief that the suitor is entitled in law could still be denied in equity on account of subsequent and intervening events, that is, events between the date of commencement of the litigation and the date of the decision. However, law is well settled that such relief may not be denied solely on account of time lost in prosecuting proceedings in judicial or quasi-judicial forum for no fault of the suitor. It would therefore not be prudent or wise to reject a claim only because of the time taken by the courts to decide the issue before it. Lapse of time could, however, be a major factor for denying compassionate appointment where the claim is lodged belatedly. A presumption is legitimately drawn in cases of claims lodged belatedly that the family of the deceased incapacitated employee is not in immediate need of financial assistance. However, what would be a reasonable time would largely depend on the policy scheme for compassionate appointment under consideration. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. The death of the respondent's father in this case occurred in December 2001. Now we are in 2025. The respondent cannot be blamed for the delay since he was diligently pursuing his claim before the appellant and thereafter before the High Court. Thus, irrespective of how old the respondent is presently, his age cannot be determinative for foreclosing his claim and bar a consideration of the same on merits. The second sub-issue pertains to the real objective sought to be achieved by offering compassionate appointment. We have noticed the objectives of the scheme of 1993 and construe such objectives as salutary for deciding any claim for compassionate appointment. The underlying idea behind compassionate appointment in death in harness cases appears to be that the premature and unexpected passing away of the employee, who was the only bread earner for the family, leaves the family members in such penurious condition that but for an appointment on compassionate ground they may not survive. There cannot be a straitjacket formula applicable uniformly to all cases of employees dying in harness which would warrant appointment on compassionate grounds. Each case has its own peculiar features and is required to be dealt with bearing in mind the financial condition of the family. It is only in hand to mouth cases that a claim for compassionate appointment ought to be considered and granted if at all other conditions are satisfied. Such hand to mouth cases would include cases where the family of the deceased is below poverty line and struggling to pay basic expenses such as food, rent, utilities, etc., arising out of lack of any steady source of sustenance. This has to be distinguished from a mere fall in standard of life arising out of the death of the bread earner. The observation in Kunti Tiwari Supra noted above seems to assume significance, and we draw inspiration therefrom in making the observation that no appointment on compassionate ground ought to be made as if it is a matter of course or right, being blissfully oblivious of the laudable object of any policy scheme in this behalf. Thus, examination of the financial condition to ascertain whether the respondent and his mother were left in utter financial distress because of the death of the bread earner is not something that can be loosely brushed aside. This takes us to the third sub issue, tasking us to consider whether there has been a proper and reasonable assessment of the financial condition of the family consequent upon death of the respondent's father. The order of the MD and CEO has been extracted above verbatim. What transpires from a bare reading of such order is that the deceased left behind him his widow, the respondent, and three daughters as his surviving heirs. All the daughters were married and settled. Only his spouse and son could count as dependents. The daughters were not shown to be dependent on the deceased while he was alive and in service. The respondent and his mother were residing in their own house. That apart, the deceased was 4 months away from retirement on superannuation. It has been indicated in such order what the last drawn net salary of the deceased was, and had he survived even after superannuation, what quantum of money would he have received as monthly pension. Also, the amount of monthly family pension being paid to the respondent's mother is indicated. Although, on behalf of the respondent, a contention has been raised that there has been no proper assessment of his financial condition, rather strangely, the figures referred to by the MD and CEO have not been disputed at all. We are thus left with no option but to proceed on the basis that the same are correct. If indeed the respondent's father would have received a pension amount of rupees 6,398 and burdened to feed himself as well as his two dependents, which his spouse and son, the amount of family pension initially sanctioned, that is rupees 4,637 and 92 paise, could not have by any stretch of imagination be seen as insufficient or inadequate for feeding two mouths. It is also not in dispute that the net terminal benefits in a sum of rupees 3.09 lakh paid to the respondent, his mother, would have been the same amount which the deceased would have received as terminal benefits after superannuation had he been alive. Thus, it is not a case where the death of the respondent's father brought about such dire consequence and or disastrous outcome that the respondent and his mother would have to cope with miserable effects which, as the respondent urged, could be remedied only by offering an appointment on compassionate ground. We regret our inability to be ad idem with learned counsel for the respondent. The next sub issue which cannot be overlooked is this. The scheme of 1993 envisages assessment of the suitability of the claimant for compassionate appointment. As has been laid down in several decisions of this court noted above, the clauses forming part of the policy scheme for compassionate appointment have to be followed to the letter. Without the respondent having been subjected to a suitability test, the division bench plainly fell in error in directing the respondent's appointment in the category of clerk, relying on the decision in Canara Bank Supra. It is of some significance that even Canara Bank Supra did not order appointment but required reconsideration of the claim. Whether relaxation in age ought to have been granted is the next sub issue. A contention raised on behalf of the respondent and which succeeded was to the effect that since he was overaged only by 8 months on the date of death of his father, he should have been granted relaxation of age, for which power was conferred by the scheme of 1993. We are conscious that there is substance in the contention on behalf of the respondent that this issue is no longer open to be decided here. The decision initially taken that the respondent was overaged had been set aside in the first round of litigation, and therefore the principle of res judicata is indeed attracted. Stop.